Right, so a very warm welcome to our building blocks. This is a webinar on an introduction to rent arrears and possession. My name is Hannah Keane, and I am a solicitor in the housing management and property litigation team here at Devonshires. And I'm joined by my colleague, Duvaraka Balachandran, who is a paralegal in the department. Just a few topics that we'll cover today. We will deal with rent arrears and tenancy types, pre-action protocol for possession claims by social landlords, the service of notices, and the some debt respite scheme as well. And then Duva will deal with issuing proceedings via both ways, PCOL and on paper, and then finally your preparation for any court hearings. So diving straight in on the grounds for possession with the secure tenants, obviously any of you with local authorities will be dealing with these mainly. It's ground one, rent lawfully due from the tenant has not been paid or an obligation of the tenancy has been broken or not performed. So there's only one rent ground for secure tenants, and that is in Schedule 2 of the Housing Act 1985. Next slide, please, Duva. Thank you. So turning to Housing Act 1988 and assured tenants, I'm sure a lot of you will be dealing with these. There's one mandatory ground at the moment, that's ground 8. And this requires that both at the date of service of the notice and under Section 8 of the Act relating to proceedings for possession and at the date of the hearing. So effectively, it's sort of a two-tranche test. There must be rent arrears at a certain amount at the date that the notice is served, and then again at the date of the hearing. As I'm sure some of you may have experienced, and you can appreciate, some tenants have a tendency to reduce these arrears in the interim or very shortly before the court hearing, which will mean that effectively your ground 8 will fall away just before the hearing. But just to talk about how many weeks or months rent need to be unpaid. So for rent paid weekly or fortnightly, that's at least 8 weeks. For rent paid monthly, that's at least 2 months. Rent paid quarterly, at least 1 quarter's rent, and then rent paid yearly, at least 3 months rent or more than 3 months in arrears. And rent in those circumstances is just rent lawfully due from the tenant. Thank you, Duva. So as I'm sure you're aware, there's also discretionary rent grounds. That's grounds 10 and 11 for the assured tenants. These, by their very nature, tend to get wrapped up in any notices with the mandatory ground 8. As you can appreciate, they're usually the fallback position if the tenant tends to clear the 8 weeks or 2 months rent. If the tenant clears that rent before the hearing, which means that your ground 8 falls away, you can still rely upon these two grounds. So ground 10 is that some rent lawfully due from the tenant is unpaid on the date on which the proceedings for possession are begun, and except where subsection 1B of section 8 of the Act applies, was in arrears as at the date of service of the notice. Ground 11 applies regardless of whether or not the rent is in arrears on the date of the proceedings, and that the tenant has persistently delayed in the rent becoming lawfully due. So if you have a tenant who is just persistently delayed in paying rent, they pay it a week late, a few days late, constantly, but ultimately is up to date with the rent as at the date of proceedings, you can still rely upon ground 11. So like you can see, grounds 10 and 11 tend to sit neatly with ground 8 so that they can still be relied upon if those 2 months or 8 weeks rent are cleared before the date of the hearing. So just to touch on future possible grounds for rent, I'm sure many of you have come across the recently published white paper, A Fair Private Rented Sector. Despite the catchy name, it will also have implications for social landlords. If you haven't come across it, the white paper was published only recently on the 16th of June, so it might be worth having a read. But in short, in terms of its application to rent, it proposes to introduce a new mandatory ground for repeated arrears. And this ground will be based on or could be used in circumstances where a tenant is in at least 2 months of rent arrears at least 3 times over a 3-year period. So for instance, if you are constantly serving a NOSP on a tenant who satisfies ground 8, but they persistently clear those arrears before the first possession hearing so that ground 8 falls away, this will effectively fill that void and give you a mandatory ground to rely upon if the tenant is persistently in 2 months of rent arrears across a 3-year period. And the notice period for that mandatory ground will be 4 weeks. So slightly different than the grounds that we currently have, but we'll come on to notice periods later down in my session. Just another thing to flag is the Renting Homes Wales Act 2016. This is actually coming into force or is being implemented from tomorrow, and will mean that the grounds for rent will change for any of you that hold stock or are Welsh providers. And it is effectively proposing that from the 1st of December of this year, 2022, there will be a wholesale move to occupation contracts, which are effectively what we currently know as tenancies. More information on the Renting Homes for Wales Act can be found in one of our webinars that we have, an overview of the Act and how to prepare for implementation. There's also a previous webinar that we did on this on our webinar hub if you're after some further information on the implications for Wales. Thank you, Duva. So just preparing to commence proceedings. As I'm sure you're all aware, I'm sure you deal with rent arrears quite frequently, is that before starting any proceedings based on rent, you must ensure compliance with the pre-action protocol for possession claims by social landlords. For the most part, this protocol is usually going to be incorporated in your organization's rent policies and procedures. So I'm sure you take these steps without even realizing that it's necessarily prescribed in a protocol. But it's best practice just to go through it and make sure that you're ticking all the boxes. Next slide, please, Duva. So just to sort of whistle-stop tour through the protocol, the protocol suggests that a landlord should contact the tenant to discuss the cause of any arrears, financial circumstances, the tenant's entitlement to benefits, repayment of the arrears, and seek to agree some sort of repayment plan. So in the first instance, always try to explore what it is that's causing the arrears and whether or not there's any particular referrals that you can make in terms of the tenant's entitlement to benefits. Perhaps they just need to be sort of pointed in the right direction, or maybe you have a team that could help them make the applications that they need to make to get the benefits. Obviously, they'll have to be eligible, but sometimes they just need to steer in the right direction. Then always a good place to start is just speaking to the tenant to see whether they are financially able to make contributions towards the rent arrears, and what that contribution would look like. What you don't want to do is sort of propose a repayment plan that you automatically know the tenant will not be able to meet. So sometimes this can be weekly rent plus £5 towards the arrears. Some tenants are in a better financial position and could do monthly rent plus £50. But certainly explore that in the first instance and see whether you can try and reduce those arrears without having to serve any notices. And, you know, ultimately it could save you some legal fees down the line. Just one thing to note, if you are agreeing a repayment plan with the tenant, is that generally speaking, if they're keeping to that plan, landlords will agree to postpone any sort of pending proceedings or service of notices that they were considering. Obviously, if the tenant defaults on that plan without good reason, etc., then you can explore what notices you can serve and what options are available to you. But generally speaking, the court won't look too fondly upon a landlord issuing where a tenant has been keeping to an agreed plan. Another sort of best practice point would be to provide rent statements in a comprehensible format, showing the rent due and sums received for the past 13 weeks. The protocol does suggest that this is done on a quarterly basis. Like I said, this might be something that's already built into your policies and procedures that you're doing anyway. But it is just worth noting, just that the tenant it's not a surprise to the tenant if you're saying, oh, there's X amount of rent arrears on your account. Another option available to you would be to apply for the arrears to be paid by DWP by deductions from the benefit. Obviously, this will only apply to certain tenants that meet the criteria, but it's certainly something worth exploring. Again, if you can sort of claw back some of those arrears without having to take any formal legal steps. Again, offering assistance in any claim that they might have to housing benefits or discretionary housing payments. Like I said before, it's just worth making sure that the tenants explored all their options in terms of any help and support that is available to them. Also, where the rent arrears are part of sort of a general debt problem, that the tenant has, then always suggest that the tenant goes off and seeks some advice from a debt advisory agency. I'll touch on the debt respite scheme in a bit, but it's certainly worth pointing them in the right direction to see whether they can get any help to deal with their debt. Next slide, please, Duva. Thank you. So if all of that has, you've sort of considered all your options in the protocol and you've not been able to reach any agreement, or any agreement that you've reached has been breached by the tenant, then obviously you have to consider serving a notice. So turning to NOSPs, notices of seeking possession, these must be in their prescribed form. These are prescribed by statute. In relation to the secure tenancies, this is Section 83 of the Housing Act 1985. And in relation to the assured tenancies, it's Section 8 of the Housing Act 1988. When you're drafting the notice, I'm sure you're aware, but just make sure that you have all the correct factual information, tenants' names, address, what grounds you're relying upon, why you're relying upon those grounds. It's really important that you make it clear what steps have been taken to work with the tenant. For example, if you've offered to help them apply for benefits, but they haven't engaged, if they are entitled to them, or if you have agreed a payment plan, but unfortunately that has lapsed and the tenant hasn't been able to stick to it, then it's certainly worth including all these reasons. And then finally, obviously, your details. And do ensure that a rent statement from the previous 2 years is attached to the NOSP. Just to flag, I'm sure many of you who were working in the sector from sort of March 2020 to now will appreciate that we have had a number of prescribed forms of NOSPs through the various stages. The latest form was revised and in place from the 1st of October 2021. So do just ensure that you have the correct form and are using it. Next slide, please, Duva. Thank you. With this new form, there are also new guidance notes. The notice is potentially defective if you are not serving it with these guidance notes. So the point hasn't necessarily been taken as of yet, but I would suggest that you reserve if the guidance notes haven't been done, just as a best practice, or if you are in any doubt. Sufficient time for service. If in doubt, give them an extra day or two just to make sure that you've got your notice periods down. We'll come on to notice periods in a bit, but obviously it's 2 working days if you're serving by first class post. Check your tenancy agreement that the method of service that you propose to do is available. Most tenancies will agree for service via first class post. Alternatively, it's quite useful if somebody can just drop it through the letterbox, because then they can complete a certificate of service and you don't have to account for extra days of service. It will be deemed served on that day if hand delivered before 4 p.m. Also worth sending by email if you have an email address for the tenant. That is just an additional service option. Some tenancies don't account for service via email, so we'd always suggest hard copy at the property and then via email. Or if you know that the tenant is residing somewhere else, then best practice to also send it to that address. Certificate of service and witness statement confirming the date, time, and method of service. Duva will touch on what to include in your witness statements when you come to issuing proceedings, if it gets to that. But it is good just to have a certificate of service because, as you can appreciate, there's staff changeover everywhere. So if you're picking up a case where a previous colleague of yours has served the notice, if you have a certificate of service, it says exactly how it was served and when it was served and where it was served. Makes life a lot easier rather than having to sort of go digging through a system to fill in the gaps. Thanks, Duva. So just turning to notice periods, I have included some of the previous ones. The second column is probably less relevant. Those the notices modified between August 2020 and May 2021 because there's only a 12-month lifespan on NOSPs, but you may still have some NOSPs that were served sort of July to October last year, which may still be in play. So that's just there for your information. What we're really looking at is the fourth column, which is the notice periods that have come into force since the 1st of October of last year. Effectively in line with that new form of NOSP. So for secure tenancies, it is 4 weeks on a ground one notice. And then for assured, again, just that last column, but I've included the third column simply for your information. And it's 2 weeks across ground 8, 10 and 11. So it just goes to show, there's no harm if you're relying upon a ground 8 to put in 10 and 11, and indeed we would encourage you to do so just as a catch-all, like I said, in case that ground 8 falls away. Sometimes we can see mandatory grounds requiring longer notice periods, but luckily for rent, it's all aligned, so you don't lose any time by including them all in your notice. Next slide, please, Duva. Thank you. So just to quickly touch on the debt respite scheme and breathing space, this came into force in May of last year and was effectively put in to provide breathing space for those in financial difficulties and encouraging them to seek some help. Some of you may have come across this, some of you may not. It kind of depends because it will require the tenant to go and seek advice and then make an application for assistance. But just to sort of speak around it in case you do come across it, a qualifying debt under this scheme is a debt for any amount that the debtor, which would be the tenant in any instances where you're taking rent possession proceedings, any amount that a debtor is liable to pay in relation to an order or warrant for possession of the debtor's place of residence or business and a court judgment. The breathing space moratorium for rent is at part 2. And it effectively, like I said, allows the tenant or the debtor to apply for some debt advice apply to a debt advice provider for a breathing space moratorium. And what this effectively means for you is that the moratorium period, if granted, starts on the date that it's registered and can last for a period of 60 days. And during this time, it will mean that a creditor, for example, a landlord in these circumstances, cannot, in relation to the moratorium debt, take certain steps unless the regulations specify otherwise or you have permission of the court. But effectively, in short, what it means is that you can't you or your agent, so for example, if you've instructed solicitors, can't contact the debtor in relation to that moratorium debt. So if you were seeking a possession order in respect of £2,000 worth of rent arrears, you couldn't contact the tenant in respect of that specific amount. It also means that you cannot serve any notice in respect of that debt. And it means that if you've already got further than the notice stage, you couldn't enforce a possession order obtained on rent grounds in respect of that £2,000 that we're using as an example. It doesn't mean that you can't contact the tenant in respect of ongoing rent liability. So if the tenant is delayed on paying rent for that month, you could contact them in respect of that. And it doesn't mean that they are absolved from continually paying their rent as prescribed by their tenancy agreement. So that is effectively just a very light touch on the debt respite scheme and breathing space. Like I say, some of you may have come across it before, some of you may not, but it's just something to be aware of and understand that there are certain things that you cannot do if you do receive notice that a tenant has entered a moratorium. And the way that I've seen this happen before is that they will put down your contact details when they're making this application, and you will receive an email effectively saying that this debt is a moratorium debt. So it's something that should be brought to your attention. But like I say, just something to be aware of if you are dealing with a tenant with rent arrears and you receive something referring to a moratorium debt. So I will now hand over to Duva that will take you through issuing possession proceedings.
Hello everyone, so I'll take you through issuing proceedings via PCOL as well as on paper, and then we'll later touch on how we can prepare for the court proceedings. So going back to issuing possession proceedings and going back to service of NOS, before we issue possession proceedings, we must always check the NOS is valid and it hasn't expired. So as Hannah has touched upon, the notice is valid for 12 months. So it is very key that the notice is still valid before you start commencing possession proceedings. One more thing that you should also check is the grounds you are relying upon, that it is specifically worded as per the House 1988, and that you rely upon the exact grounds that are specified on the NOS. Please ensure that the correct form is used, and also the time frame for expiry is also provided. I know majority of the landlords now do take their own court proceedings, and usually officers do prepare their paperwork and present the case in court. So it is very, very crucial that you do, before you do start issuing the proceeding, you look at the NOS, the validity, the grounds, before you do seek possession or start issuing a claim. Again, there are two ways of issuing a claim. One is via PCOL. This is an online platform for issuing court possession claims, or paper-based. We'll start with PCOL, which is the online-based platform for issuing possession proceedings. Again, this is purely for rent arrears only. So anything to do with antisocial behaviour, not the right route. So only rent possession claim. Again, you will have login details for this, and it's simply going on to the website possessionclaim.gov.uk/PCOL. If you haven't already, we will suggest you register this, because it's a very simple way to issue possession claims rather than doing the old-fashioned paper form. So when it comes to the PCOL application form online, it's very, very basic. It takes you through each of the section one by one, and it's basically you fill in the claimant's details, which will be yourself. Again, you add a reference, which is the ID of the property or the name, and then you add the claimant's name, who is the landlord, as well as address for the property. Sorry, address for the landlord details, who is the claimant. Then you will go into filling the grounds, and again, this should be the specific grounds as specified in the notice of seeking possession that you have issued and you will be relying upon. Then you will go on to inserting the property address and the defendant's details. Again, it is crucial that you add the defendant on the PCOL application. So when you are on the claim form, there is an option to add the defendant. In the event you don't add the defendant, that does not appear on the claim form. So please do double check this when you are issuing via PCOL. And the property address is the address that you are seeking possession of, and that is usually the defendant's address. Again, when it comes to the PICO application, please do fill in every single detail that is specified on the form, and that's usually the tenancy type and the date. So either an assured and assured short-haul tenancy, the date of when it commenced, the current rent, and the daily rate. So the daily rate is usually, if it's a weekly tenancy agreement, you divide that by 7 and you get the daily rate for the property. Then you'll go into the reasons why you are seeking possession, and that is again the grounds you're relying upon, and is usually specified as the fact that the defendant has not paid the rent, and for how long. The steps that you have taken, again, crucial. So this will refer back to the arrears letters you have sent out, the times you have engaged with the defendant, any attempts you have made to support the resident, i.e. the defendant. So do specify this on the application as well. Then it does ask for the notice type that you are relying upon, and this is a notice of seeking possession, also known as the NOSP. So please tick that option and also put down the date this was served. There is also an option that refers to the defendant's circumstances, and it is quite crucial that you do add the details in terms of whether the defendant is paying regularly, if they are not paying regularly, why they're not paying regularly. And again, this is to do with housing benefit payments, universal credit payments, or the defendant simply just refusing not to pay at all. So this is the way you can just write a little bit about the defendant, any vulnerability, any support, any payment attempts they've tried to make or not made, so that it just provides a little background in terms of the defendant's circumstances. Again, it's very crucial that you also tick the money judgment option, so that when you do obtain the possession order, again, I'll touch upon that later, that you get a money judgment for the sum of arrears owed. One more thing that you should also outline on, or you should fill in, is the payment details. And with regards to the payment details, what we normally recommend is that you add a few payment details. This includes the payment at the time the notice was served, i.e. the NOS, the last 3 payments that's been received, whether it's housing benefit, universal credit, or the defendant's payment. If there's been no payment from the defendant at all, then you just simply put in 0. And then most crucially, you add in the payment as of the date of issuing the claim. So it provides a small little summary in terms of the payment history to the judge when they do look at the application. Again, last bits of the PICO application itself is you do a statement of truth, just declaring what you have put on the application online is truthful. And there is also a fee of £355, and that is the current fee at the moment for any possession claims. Once you have issued the PICO application, you are automatically given a claim number, and this will be the claim number that you'll be using going forward when it comes to this matter in all court correspondence for court matters. So this is the number that you'll be using for reference. Again, do go back to your PICO regularly to see whether the notice has been issued, if the matter has been listed. There has been instances where the claimant who was making the application has not received a notice due to admin, or because the correct email has not been put through. So it is very crucial that you do go check in on the PICO portal to make sure that the claim has gone. Secondly, that the notice of issue or the notice of hearing hasn't been left unread. So again, one thing to take away from here is making sure you check your PICO application regularly. Now we go on to the paper-based application, and this is simply by filling in the N5 claim form, the N119 claim, which is the particulars of claim, and then also you attach an N119 rent account, and then you print this out. So so going back to that again, so you do the N5 form, the N119 form, which is the particulars claim, then you attach again rent statement, tenancy agreement, and a NOS. It's always good practice to provide all the information, provide 3 copies as well. When you do a paper-based application, again, 3 copies, all of the exhibits. This is including the rent statement, the notice, which is the NOS, a copy of the tenancy agreement, and again, best practice to provide the correspondence you've sent, i.e. the arrears letters, AR1, AR2, AR3 letters. At this moment, the COVID notice is not required, so we have returned to the pre-COVID-19 process. So now going on to issuing the proceedings, and like I touched upon before, you have to send 3 copies of the claim form, the particulars of the claim, as well as any exhibits that you are also attaching. The reason why you do 3 is 1 is for the court, 1 is for the defendant, and 1 is returned back to yourself. So it's always mandatory that you provide 3 copies of all forms, so the N5, N119, and also any exhibits you are providing as part of the form. When you do send the court, it's again, you need to double check which court you are sending to. I know there has been a lot of changes in courts in terms of locality as well. So if you go onto the government website and if you just follow that, it does tell you, if you enter the postcode for the defendant's property that you are trying to seek possession of, it tells you the nearest court. Majority of the circumstances can be Clerkenwell or Central London. So it is very crucial that you do check the court that is relevant for this claim. Once you have sent this across, the court will then issue a notice of issue and then a notice of hearing, which will list the possession hearing date. So preparing for the actual hearing itself. And one of the things that we always advise in terms of best practice is to do a witness statement. Again, it is not mandatory, but it's good practice. The reason why we suggest that is that it provides the judge, the defendant, and also the counsel or yourself going to court exactly what has happened in terms of the history of the proceedings. In terms of the CPR rules, you must file the witness statement again, not less than 2 clear days before the hearing, and again, you will need to file and serve this at the court and serve it on the defendant. Again, when a witness statement is prepared, it is very crucial that you outline and you exhibit a copy of the tenancy agreement, a copy of the NOS. Going back to what Hannah said before, the certificate of service. In majority of the circumstances, it might not be the same officer who served the notice actually taking the proceedings or issuing the possession claim. So a certificate of service, it is mandatory that you provide as part of the witness statement as well to confirm that the notice was served and by which way. Again, it is great to exhibit the rent account. So at the time of actually issuing the proceedings, the rent account might be less or more. So it is very, very good practice to provide a rent account from the date of arrears to the date of the hearing. And again, provide an update on the defendant's circumstances. So in terms of the housing benefit position, DWP, any other benefits they're receiving, university credit, if the tenant's gone on to PIP or any kind of circumstance changes, it's very crucial that you outline this on the witness statement. Again, with the witness statement, it is very crucial that the person who is doing the witness statement is familiar with the content of the statement, because there is a high possibility that the defendant might seek legal representative or even ask a duty solicitor. So you might, and even the judge might cross-examine you at the hearing. So the claimant who is, or the witness statement, the person who's doing the witness statement should attend the hearing and also be familiar with the contents of the statement. Before the hearing, review the file, do a review of the rent account, see whether there has been any changes in the housing benefit payments, whether anything has been received. Again, if there's been any changes into the entitlement details, whether there's a shortfall, whether there's a shortfall payment. So it's very good that it's very good if you can review the rent account before going to the court proceedings. If you are presenting the case in the court, just flag up the relevant items. Again, the witness statements will really help with this because it will lay out the chronology of what's happened and will exhibit exactly the relevant documentations, i.e. the tenancy agreement, the notice, the rent arrears, and also the rent statement as well. Like Hannah touched upon previously, it is crucial that you do follow the pre-action protocol for the for rent arrears. So just make sure that you also cover this on the statement. When you do attend the court, it's again back to basic where you make sure you are presenting yourself in a professional appearance. As soon as you go into court, report to the clerk or the usher to confirm that you are at the hearing and who you are representing. Again, be clear in terms of what you are asking for, the type of possession order. I will cover that in the next couple of slides. If you are representing, please be ready to answer questions under oath. And again, going back to the statement, make sure that you are very familiar with what's on your statement. Orders. So when it does come to a possession proceeding and the outcome that you're seeking, the court can make the following orders, and that can ideally be possession forfeit. So this is where, as soon as the court hearing is, as soon as the judge orders the possession, you can apply for possession of the property by doing a warrant of possession. Or you can do, or there can be possession in 7, 14, or 28 days. So you have to wait for 7 days since the order is granted, 14 days, or 28 days. The third option is a suspended possession, and this is where a specific date is provided on the suspended possession order, saying that a date of possession can be obtained on a later date. Again, there can be an adjournment, and judgment generally on terms, and this is normally on the common rent plus some arrears, and again, permission to restore as well at a later date. Again, one thing that we don't want is an order striking out the claim or dismissal. So ideally, it's the first 4 options, and ideally not the 5th option. So if you try and follow the process that we've outlined at the moment, it should hopefully not result in the last order where a possession order is striked out or dismissed. Again, those are the orders that you should be seeking for, the first 4 orders and not the 5th order. Please be clear when you do go to court that you are clear in terms of what order you are seeking. Again, the court should not be making a postponed possession order, so you should be obtaining a suspended possession order with a date of a fixed possession, with a fixed date for possession. So if you're not able to get an outright possession order, try and seek for a suspended possession order. At least this way you can agree a common rent arrears. In the event they don't pay that sum, you can then apply for possession afterwards. Again, defending proceedings. So if the tenant does attend and alleges that there is a defence or a counterclaim, then you will proceed at, then there is an unlikelihood that you'll proceed at this hearing in terms of obtaining the possession order that you would see or you would like. So you should always ask to ensure that the court direct the tenant to file and serve a formal defence, rather than just agreeing to general adjournments or general directions. It is important to involve a solicitor if a claim is defended. If a claim is defended, it's just more protection for the claimant. After the possession order is granted, again, monitor the rent account to ensure the arrears are repaid. If the tenant does seek to vary the terms, advise him to make an application to court. Any orders cannot be amended unless a formal application has been made to the court. So please advise this to your residents. If there is non-repayment, seek to enforce and obtain an eviction warrant. You've got an order where they're suspended or an outright possession order. They're not making payments. Just enforce the order and obtain an eviction warrant. And that's all from myself in terms of issuing a claim and also preparation for court.
Thanks, Duva. We've had a number of questions come in. I'll just deal with the broadest one first. You will receive slides by email at the end of the webinar, so not to worry at all. These will come through to you a little later this afternoon. We have had a few that came in prior to the webinar, one of which was dealing with, and I can see that it was repeated again in here, just regarding ASTs and rent. So ASTs can be dealt with in the usual way with the Section 8 NOSPs of assured tenancies. Obviously, you also have the Section 21 route available to you for the moment. The white paper, Fair Private Rented Sector, in there, the government does propose to abolish the Section 21 procedure. So for now, you can do the NOSP as the Section 8 notice, as I went through earlier with the assured tenancies, or of course you could serve Section 21 notice, but just bear in mind that that's available now, but will not be available permanently. There will be a time when it is abolished. Just turning to another one regarding the inclusion of grounds 10 and 11 at the time of serving the notice. This is again just what I touched on, the two discretionary grounds that we tend to sort of use in the round with the mandatory ground 8. Yes, we would suggest including all of them in the NOSP. You will have the opportunity to potentially serve a second NOSP, and then you could issue proceedings on all 3 grounds. But it's just a bit neater in terms of housekeeping and keeping track of things if you put ground 8, 10, and 11 and just roll it all into one notice. Another question regarding the new mandatory rent ground that's proposed by the white paper. If a tenant is 2 months in arrears for the 3-year period and has never been below, can the new ground be used? So the wording of the new ground, or the proposed wording at least in the white paper, is that a tenant must be is in at least 2 months arrears 3 times in the last 3 years. So provided they hit that 2 months threshold 3 times in that 3-year period, this proposed new ground should be available to you. I'm just having another quick look through. I think, Duva, you had another one that came in before the webinar. Do you want to just touch on that? And I'll read through these other ones.
So one of the questions we received was bundles. So in relation to whether bundles should be filed ahead of hearings and what courts require. I think the best practice is normally it's not required, simple terms. However, it's best practice that you do file a bundle, and that's normally in the form of witness statement, where the witness statement already exhibits your tenancy agreement, the notice, the certificate of service, and also attempts you have made to engage with the defendant. So that's very crucial. The witness statement basically just outlines the steps, and the exhibits basically just reinforce what you've said on the witness statement. So simple answer is no, it's not required, but it's always best practice to provide that. Just makes things easier for yourselves when you do go to court.
I've seen a few regarding the COVID requirements and information in the witness statements and the COVID notices that were brought in by Practice Direction 55C. So if proceedings were issued prior to the 30th of June, courts are still looking for those notices to be served and brought to the hearing. And in those instances, I would also suggest that you include whatever information you have in your witness statements. So for instance, if you issued a claim on the 1st of June, but you have a hearing upcoming at the end of this month, then you will still need to do those COVID notices and bring copies of that to court, and I would also suggest addressing it in your witness statement. If you have issued a claim after the 30th of June, those requirements no longer apply. So I think there has been some confusion whereby people are attending court now, for instance, after this 30th of June date, and are being asked for these notices. So that is just the reason why. The likelihood is if you are going to court sort of in the near future, you probably issued these claims some months or at least weeks ago. So I would suggest just double checking. It will be the date of issue that you will need to be certain on. Duva, there is a question regarding attaching documents to PCOL. For example, the NOSP and the tenancy agreement. Do you just want to talk through that one?
Sure. Normally there isn't a link to actually attach any supporting documentation. You just put the dates and the notice type and also the tenancy commencement dates. This is where, so I think one of the questions was adding to that was sometimes the judges or the courts do not have a copy of the PCOL application. So this is where the bundle might again be helpful, or the witnessing might be helpful, where you just exhibit the same information that you are filing pretty much 7 days before the hearing for both to the defendant and to the court, outlining exactly what exhibits you have. So simple answer is sometimes I might not be available on PCOL. the best way to overcome that is by doing a witness statement, putting those exhibits in, so that way you are referring to an actual documentation when you are at court.
Thank you, Duva. Just another question following up on the new ground from the white paper, and whether or not this proposed new ground is for private or social landlords. My understanding is that it will apply to social landlords as well. So it will be available to you. Like I said, effectively just to fill that void where you've been trying to rely on ground day, the tenant has knowledge of the process, takes those arrears down below the 2 weeks or the 8 weeks rent just prior to the hearing. So yes, my understanding is that will be available to social landlords as well. And then again, just a follow-up question from when I addressed the grounds 10 and 11 being included in the NOSP with ground 8, and whether or not effectively a second set of proceedings will have to be issued to rely upon these. No, what you could do, if you've served a ground 8 notice and you've issued proceedings on that NOSP, then you could serve a second NOSP and then apply to amend your claim form, in particular as a claim, to include grounds 10 and 11. Or alternatively, if you served a ground 8 NOSP, decided you also want to include grounds 10 and 11, the notice period for 10 and 11 is only 2 weeks. That's not going to make a huge difference in the grand scheme of things, at least from my experience with the court timescales at the moment. So you may just want to wait until that 2-week period is ended and then issue proceedings on all 3 grounds, and then obviously you would just need to show service of both NOSPs. So the ground 8 NOSP and then the secondary ground 10 and 11. But if you can wrap them all up in one, like I said, it's just going to be administratively easier for you, and in terms of dealing with the drafting the pleadings, etc. I think, Duva, there's another one that's come up regarding the entering the payment history in PCOL, and where it says you stated to enter a few of the payment dates, but what is best practice in terms of how far you should go back if the debt has been outstanding for over 2 years? I seem to recall there's specific dates that PCOL request, but you're probably better placed to comment on this one than I am.
So usually it's the 3 payments, 3 to 4 payments. That's normally the payment as the arrears at the sum of the notice was issued. So the sum on the NOSP, and the last 3 payments in terms of what payment was received from the defendant. So for example, if your notice was issued last week, then you put the last week's date and also the sum owed as per the NOSP. And if the hearing is coming in next month, for example, and the defendant has not made any payments at all, there's been no housing benefit payment, no universal credit payment, no payments at all, then you put down the last 3 payments in terms of what was due, so the last 3 weeks, and also the payment that's due at the time you are issuing the PCOL application. Do not put all the payments down. The reason I'm saying that is because you will be exhibiting a witness and a rent statement to provide the history of the rent account, and that will be from the time the account was in arrears to present.
Thanks, Duva. I've just got another one regarding, I think it's in relation to where you've served a NOSP, but you haven't included or appended a 2-year rent statement to that NOSP. And I touched on this a bit earlier, effectively as best practice when serving the notice. It is not a statutory requirement that the 2-year rent statement be appended to the NOSP, but we would suggest best practice, send it with the notice. What you could do if you've served the notice and not sent it, just send the tenant another letter and say, here you go, a 2-year rent statement for you as well. Like I said, with the protocol, you should effectively be sending rent statements for the past 13 weeks quarterly. So they should have at least a relatively up-to-date snapshot of their rent account. But like I say, it's a best practice suggestion. I wouldn't suggest, withdrawing your court application or starting again, which is what was put in the question. I would just say, no for next time, and include the 2-year rent statement with your notice. Another one on the Section 21 procedure and whether or not they're being removed. This is a proposal that came in or was brought to the forefront of everybody's minds with the publishing of the white paper, A Fair Private Rented Sector, and it is an intention of the government to remove the Section 21 procedure. And in line with that, there are some new possession grounds, one of which was touched on earlier in relation to rent. There are others regarding the other grounds that we see in Schedule 2. So it's just something to be live to. I don't have any details on the time frame for that implementation coming in, but it's very fresh because the white paper was only published last month. One more regarding where a hearing has been adjourned. I'm not sure whether this is one where you've got the first hearing and somebody's just asked for more time and it's been adjourned for the first open date after a certain number of days. That is usually in the hands of the court. You will receive a notice of hearing in due course. Where the matter has been adjourned, generally with liberty to restore, you will need to make an application to the court asking that the hearing be restored. And this is just on the usual N244 application form. One last one for you, Duva, if that's all right, just clarifying on the PCOL payment history. Would you encourage that we record 3 payments, not pan over a period of consecutive weeks? So effectively, how should those payments that are put into PCOL be staggered, I think?
So in simple terms, so if you're going to do 3 payments, it will be the date of the payment when the NOS was issued, and then and then on top of that, so that'll be the first payment you will enter. Second payment will be if they received a universal credit housing benefit, the defendant made a payment, and that if not, be the last 3 rent payments before the claim is issued. I hope that clarifies that.
Lovely. Thank you very much, Duva. Thank you very much, everyone. Oh, sorry, I did have one other that came in prior to the webinar that I just want to touch on regarding abandonment and rent arrears. I think this person was just querying whether or not you could rely on rent to recover possession of a property that's believed to be abandoned. The way that we would usually suggest doing it is if you're of the firm view that the property's been abandoned and the tenant's no longer residing there as their only in principal home, perhaps serve a notice to quit on the basis that they've lost their security of tenure because they're not occupying as their only in principal home, and then you could serve a without prejudice NOSP relying on the rent grounds, and then when it came to issue you could plead them in the alternative. I appreciate that abandonment is quite a threshold to get onto, but you could have the NTQ as your primary position and then the rent grounds in the background if you needed them. So I think we have dealt with the majority of the questions that we've had in now. We are a few minutes early, only 4, but thank you very much everybody for your time. If you have any other questions that crop up after the webinar, feel free to get in touch with myself or Duva. You will get the slides with our emails at the bottom. I appreciate sometimes it takes some time to digest these things and then you think of something that might be helpful. So yes, thank you very much for your time. Have a wonderful afternoon. And like I say, any other questions, let myself or Duva know and we will be sure to answer them as best that we can.